Hello, I am Patricia Fonte of Fonte Law, where we practice estate planning with heart. Estate planning with heart means that we know that we cannot be our client's only advisor. And it also means that we need to keep up not only with the law, but with best practices. And where do best practices come from? Lived experience. Learning from world experience is a big part of what we do. And that's why listening is a key part of our client experience here at Fonte Law. I hope that we spend more time listening than we do talking. And today we are going to listen to two incredible experts. We have Carolyn Rosenblatt, who is a retired nurse, public health nurse, and she's also an attorney. And you can find a lot of information about her at agingparents.com. She consults with families on age-related issues. She has 27 years of personal injury litigation and trial experience, and she's a subject matter expert in age-related healthcare, legal and financial issues with families, and she mediates family disputes. She is an ABA published author, and she volunteers at the Marin County Courts. If you've never seen the Marin County Courts, they look like something out of Star Wars. They're really incredible. As a settlement panelist, she's passionate about wellness and has developed successful strategies for managing stress within the legal practice and beyond. Also with us today is Dr. Mikol Davis, and he is a clinical psychologist with over 45 years as a mental health provider. He's a subject matter expert in aging issues, particularly testamentary capacity. And we have a lot of estate planning lawyers in the room today, and we all, testamentary capacity is an obsession for us. Also, dementia and cognitive impairment. He maintains a therapy practice and is a consultant and co-mediator with his wife, Caroline, at agingparents.com. He has extensive experience with family conflicts and volunteers at the Marin County Courts also as a settlement panelist in high conflict matters. He's treated many lawyers over the years who have suffered from unmanaged stress. He teaches tactics for stress management. And today, what they are going to talk to us about is how should you name a successor or an agent in the event of incapacity? Now, a knee-jerk in a lot of estate planning, and I think our drafting software pushes us this way, is two independent doctors. So let's learn whether that works, and if it doesn't, why it doesn't work, and what we should be doing instead.
Thank you, everybody. Good morning. And thank you very much to Patricia for organizing this. It came about because I commented at one point that I hate the two-doctor rule. And she said, why? And that's why we're doing this today. We're going to explain to you why that doesn't work very well. I think every estate planner and people who are associated with them needs a little more creativity. I'm not an estate planning attorney, but I see what happens long after the estate plan is drafted. And we see pitfalls, particularly in the incapacity clauses that get drafted. A lot of these are sort of automated, two doctors, two physicians, and so forth. The wording in the trust drafting software can cause a real problem. Who can serve as trustee? Well, what's wrong with having two doctors? Doesn't that protect the client about one doctor not being right? And maybe somebody dishonest pushing them into the decision that they don't want to make about who's capacitated? Well, it doesn't necessarily work. In theory, it sounds good, but in practice, what we see decades later, you don't know what happens, but we do. They come to us in distress. This is a huge problem that we have seen over and over and over again in our consulting business. We work with families, typically the adult children of the aging person. We see it a lot, and that's why we're talking about it. So here's the trap. They have to be declared incapacitated by two physicians before the person can be removed as trustee. Let's say the trustee's got cognitive problems. They won't resign. Then we have to look at how this software came to be. Whoever designed it, and I think it was in the 60s from what I've learned, they were ignorant of our medical system of today before it got so fragmented. So they're going to be several discussions about the reasons why this wording creates issues by itself. We'll go through them one by one, and then we're going to tell you about two real cases, not hypotheticals, in which the drafting of the lawyer really saved the day. All right, the first problem with the needing to go to two doctors is that cognitive decline, even in the early stages, often prevents the person from getting it, that they're impaired. They feel fine physically, they'll tell you, They're not going to go to a doctor. What do you mean I have to go to a doctor to get evaluated? You think I'm crazy? They're not going to go to one, much less two. The second reason is that this idea back in the 50s where there was, Dr. Welby or somebody's long-term family doctor, well, of course we know. Oh, yeah, we know you're losing it, Grandpa. We'll sign off. That'll be fine. That is not reality for most people today. Does it ever exist? Yeah, once in a while. I've seen it maybe twice. But these people with multiple chronic health conditions for which we are successfully keeping them alive with bazillions of medications and treatments and surgeries and so forth, which doctor? The rheumatologist, the cardiologist, the orthopedist? Which one? So how long does it take to assess an elder for cognitive ability to see if they can serve as a trustee still? They're not just going to one doctor who knows them well. Trust me on that. The other reason, and I learned this a lot in my personal injury practice over the years, was that a lot of doctors are intimidated by the legal process. They don't want to get involved. They're afraid they're going to have to take time and testify. They don't want to be in a court case. They don't want to deal with extensive assessments. What if they get it wrong? So they just say no. You ask them to address this and put it in writing, they say no. The other problem we have with our oldest clients is that if they've been going to a doctor for a long time, the doctor retires and then they've got a new doctor. And that doctor, whichever specialist it may be, doesn't know them yet. So they're the only ones available to even see the client, much less do a cognitive assessment. So you can't get a reliable assessment to determine whether the person can still serve as trustee from just any old person. So let's talk about cognitive decline. I think everybody's run into it. If you haven't seen it in your own family, you've seen it in other people, clients perhaps. The statistics are extensive, but let's just know that after age 65, the risk of dementia doubles every 5 years. And at least 1 in 3 are the chances by the time a person reaches 85 years old. Now, a lot of us might have a 90-year-old who's just great, but there are millions and millions more who aren't yet diagnosed that I hear about from their families. Oh, mom has memory problems. Oh, mom forgot to pay the mortgage. Oh, mom this. Oh, dad that. They don't have a diagnosis, but that doesn't matter. They are impaired. And how frequently does cognitive impairment lead to dementia, Mikol?
Frequently, but the lead time can be up to 10 years.
Sure.
So we don't know a lot of times when there's a definitive diagnosis of dementia, when it actually happened and started to impair their ability to act.
That's right. All right. So you draft the trust. Years later, the client develops cognitive impairment. They are targets. Information is bought and sold. AI is making it even easier for thieves and predators to go after them. Elder abuse is a $37 billion a year problem in this country alone. It is a worldwide problem. Then there are family fights about how impaired dad is or how impaired mom is or how impaired the person is who's the trustee. Can they handle the trust safely? Well, after they've been ripped off once, somebody says no and another person says, oh, that only happened once, it won't happen again. The money in the estate can get ruined and taken by predators. They will steal a little at first to test it out, and then it gets bigger and bigger, and pretty soon we're talking hundreds of thousands of dollars. So this is what commonly pops up for us. The trustee, usually the husband, gets ripped off by somebody. Family gets upset about it. He will not go to see a doctor. He won't resign. More financial abuse continues and escalates. Money losses continue. And then when the elder starts to need home care or help, there's not enough money to pay for it. The trust can itself create a brick wall for the family. If they've got aging parents who are losing the capacity to make financial decisions, this is distinct from testamentary capacity, financial decision-making, and they will not go to see 2 physicians, what happens then? Everybody is stuck. And often there is a confluence between the point at which they really need care and help with their activities of daily living at home and the point at which the expenses that have been ripped off continue to go up and up and up. The whole estate can be destroyed at the worst case scenario. All right, so we're going to talk about 2 cases. One involved an elderly gentleman with 4 kids. The other was a wealthy widow who lived with her boyfriend. And we're going to go through how the lawyers who had drafted those 2 trusts did not limit this to the 2-doctor rule. They were outstanding and saved the elder from decimating abuse. All right, let's talk about the old engineer. He lived in a home with his wife. He had 4 adult children. He was devoted to his only brother, who was being cared for full time. The caregiver had gotten a way to manipulate the old engineer and had talked him into giving her money. Oh, I just desperately need it for my mother. Oh, I desperately need it for this or that. Her family was from Peru. Someone in the family commented that the dad was probably furnishing the home of everybody in Peru. She continued to abuse the dad, and he continued to fall for it, regardless of his education, regardless of how careful he was. The trust said that he could be removed if 2 medical doctors declared him incapacitated, but they tried logic and persuasion, and there was no 2-doctor thing going to happen at all. He just wasn't into it. He thought he was fine. This attorney, who actually visited the elder and tried to persuade him himself to resign, he had taken an extra protective measure, and this is what we hope you'll focus on. He had created another option for the family, which the engineer dad had consented to at the time of drafting. When he was younger, when he was in full control of his thinking, he said a majority vote of his 4 kids about incapacity would be sufficient to remove him as trustee. Well, thank goodness. We want you to build in protections against financial abuse. People don't think it's going to happen to them, but it can happen to anyone, no matter how smart, educated, great with money. We've had financial advisors, accountants, people who are CEOs in major companies, all fall victim to financial abuse with dementia. You're the counselor at law who should put protections into your trust to keep these estates safe, and you can't do it with the 2-doctor rule if that's all you do. All right, so this solution came about after several meetings with the family. The gentleman, the old engineer, would not go to the doctor no matter what anybody said to him. He denied that he was being abused because he kept careful records of every loan, and there were pages of them that he'd given to the caregiver for his brother. He spoke well. He made a good appearance. If somebody said, well, go get a conservatorship, then you can stop him, that would not have succeeded in all likelihood. There were no other options built in other than what the lawyer had drafted, and thank goodness he did. So the children got together. They consulted with the trust attorney. They voted him out as trustee. They didn't know how to tell him. This was very awkward. So we had another in-person meeting after several with the family. All of the adult children showed up. We broke the news. The old engineer was furious. First he was calm, then he got really angry. And his kids said, look, it's too late, Dad. But the alternative to allowing this panel of his children saved everyone. His wife later developed dementia, and the last I heard, they were both in need of full-time care. It was really sad. All right, so just know that there's lots of research on the subject of financial capacity as distinguished from testamentary capacity. I've outlined all that in the book, which is listed at the end on resources, but that starts to diminish early. When somebody is moderately impaired cognitively, their financial capacity is already significantly impaired.
And common among most folks, they believe that the symptom when they're starting to lose capacity is actually their memory. And what we've found is that, in fact, it is their financial capacity that often starts to be diminished, regardless of what their short-term memory is.
Right. And it's not a either or cut and dried. It's a subtle thing with a lot of nuances in it. So what are other people doing? What are other lawyers doing? We're going to get into this in a little bit more detail, but some people have a chosen committee would be the deciding entity rather than just 2 doctors. You can leave the 2-doctor in there if you want to, but don't make it limited to that, please. The committee in this old engineer's case was the kids, but if they don't have kids, they could use a committee of friends. Please, I beg of you, make sure they choose younger friends. We have a 91-year-old right now who was being abused, was still the trustee. She had appointed her brother. He's 88. He's visually impaired, can't travel, and can't make a decision. So it has to be a committee that's broader than that. One treating physician is what some people use. Obviously, testing psychologists, which we're going to talk about in a minute. The trustee held under duress, which is the subject of the next case study. And in one case we saw, which was very helpful, the lawyer had drafted into the trust that if the co-trustee, in this case was the wife, requested that her husband, the other trustee, be evaluated by a physician and requested it in writing, and he refused, after 30 days, that succession to her as sole trustee automatically passed. Those all have worked. All right, Mikol, talk about psychological testing. That's something you do.
I do. Thank you very much. So This is something that's probably a level of information that you're not necessarily very familiar with in terms of the nuts and bolts of what psychologists do when they do neuropsychological testing or psychological testing. Psychologists are the only ones that are really licensed to administer these kinds of tests that reveal different aspects of people's capacity. MDs are not licensed to do these kinds of neuropsychological tests. Most importantly, what they do is that they provide objective data, which is normed based on the person's age and education. And as you can see on the slide, one of the things that is determined through testing is memory. We look at short-term memory, long-term memory. We look at their conceptual ability. We look at their abstract thinking. We look at the fluidity of their language. And we take that information into account and also look at current medications and determine whether or not that is playing a part at all in their ability to both have testamentary capacity and also financial capacity. And I can tell you, I've been practicing for 45 years, and I'm yet to find a physician or often other psychologists who haven't done any kind of forensic work who are able to even understand the difference between testamentary capacity and financial capacity. The way that the actual tests are administered, a traditional testing involves at least a combination of different tests. Psychologists are taught that in order to have a definitive diagnosis, you have multiple data points. So you can't just do like what they call the MoCA or the Montreal test for cognitive impairment, or you can't do what's called the mini mental, another short test that is sometimes done in doctors' offices for 15 minutes, which is a quick list. You need to have multiple tests, and I often test, and my battery of tests, it usually takes at least 3 hours. There are other psychologists that'll do full batteries, which are full or half days. When we're answering the questions specific to capacity, I think these full batteries are overkill because they're often looking at the origins of what might be affecting the diminished capacity versus just whether they have it or not.
So if your client is being abused and you hear about it, especially people in financial services, you're mandated reporters. So you call APS. Well, so what? They're not going to do anything unless there's some huge entity that can be sued or brought with criminal charges against them. Basically, when, evil son is ripping off dad, that does not rise to the level that APS in most counties is going to act at all. And if you try to hire a litigator and the abuser was a caregiver that stole money from dad or mom, took all their jewelry, whatever, that's not necessarily worth pursuing either because they've spent the money and there's nothing to get out of that kind of a case. And as we all know, conservatorship now, since Britney Spears, is expensive, usually a lengthy process, and it can readily fail if the proposed conservatee shows up and makes a good appearance for the judge. And of course, they're all represented by an attorney appointed by the court whose sole objective is to object to the conservatorship and to try to stop it from happening.
And what about the financial abuse that often happens within the family and the family doesn't want to take action?
That's right. I mean, they're ashamed, they're embarrassed, and they don't want to make that public. So it's really sad, but conservatorship is not the answer to solve the problems, as many people have been told. So let's talk about another case study. This one had the highest drama because it involved all kinds of things, and Mikol was involved in actually going to the home and dealing with the boyfriend. The live-in boyfriend of this elderly woman was ripping her off, had been taking money out of her account. She had one son, and the son, after he realized that the boyfriend was stopping him from visiting his mother at her own home, and the bank had reported a suspicious activity of a $30,000 withdrawal from her account. There had been many withdrawals. They finally got with it and reported it, but then they froze the account. The son was stuck. He had no idea what to do. We got involved to try to work with the estate planning attorney The abuser had to be stopped. He kept canceling the Kaiser appointments. This woman was a Kaiser patient, and they have a mechanism where multiple chronic illnesses are addressed. All great, but you got to go there. The nurse from Kaiser had come to the home. Boyfriend wouldn't let her in. So we set up with Kaiser, the local sheriff, which in this jurisdiction had power over this location, APS and Mikol to go to the home to ensure that she would keep that appointment that had been previously canceled. And that worked. But this took a couple of months. And subsequent, getting the boyfriend out with a restraining order was the solution to ending the boyfriend's abuse for good. But Mikol, talk about what happened when you got there. With this solution, which was get her there no matter what it takes with the police in hand.
Well, the sheriff's department knocked on the front door, tried to get access. The old man wouldn't let the sheriff in. The son arrived with the APS worker. We went around the back to a sliding glass door where we could see both the older lady and the older man sitting in the living room. Sheriff kept on knocking on the sliding glass door. The old man finally let us in. As we walked in, I looked down to the right next to the sliding glass door and saw a rifle. Alerted the sheriff so that he saw that, and we began to interview the old man and the old woman to find out what their status was. Unfortunately, the sheriff, who was using logic trying to get answers, wasn't getting anywhere with the cooperation. And I finally took him aside and said, these folks are beyond logic. What you're going to need to do is make a forced choice, which he did, at which point we were able to then get the woman out of the house and get the evaluation done.
Right. And the sheriff had to tell the boyfriend that he'd be arrested if he didn't cooperate.
Yeah, that was the first choice.
Yeah. But this was interesting because the lawyer who had drafted the trust, who was somebody I knew, had put in some alternatives to the need for 2 doctors. Again, she saved the day. She had included that the trustee would be determined to have resigned if she were held under duress for 30 days. Well, it had been more than 30 days, and the son was certified as the successor trustee, but that still created a problem because the bank that had frozen the account did not want to accept the choice that the trust had provided. So the lawyer involved had to advocate. I had to help the son advocate. The trust attorney communicated repeatedly with the bank, showed them the trust provisions, et cetera, and finally they unfroze the funds. But that was not a simple process. And after all that, the elder abuse restraining order resulted in the boyfriend being forced to move out, which he did. So the last I heard, the son had moved in, he was taking care of his mom, and that was okay. We don't want to rely on conservatorship as a solution if they will not see 2 doctors. It's gotten harder and harder. These are expensive. They're difficult. It takes months. Even if it's an emergency, the court, whatever jurisdiction it may be in, may not see it as an emergency. If the elder is housed, clothed, fed, and so forth, making the case takes real advocacy, and it's an art form that not everybody has. So think about that. All right. So some lawyers anticipate that a client isn't going to go for the 2 doctor thing if they have 30 days go by. And so the case in which we saw the lawyer had written in, okay, if you, the wife, request that your husband will not go see a doctor, much less 2, and a month goes by, they will have been deemed to have resigned. That works. The case that we're referring to here involved not only a guy who was getting ripped off at his business, in which he was still participating, though incompetent. He was still driving and had been in multiple car accidents. And we had to engage the police to kind of stop that driving thing. But the wife was competent and her husband was incapacitated, and it did work. The 30 days refusing to see someone request in writing. All right, so what do we take away from these 2 case studies? These are 2 of many things that we have seen. We picked some high drama ones for your entertainment, but there are less dramatic situations that happen quite often. Nobody should be limited to the 2 doctor rule. It's outdated. Our medical system doesn't make that simple. Has it ever worked? Yes. We've seen cases where there are 2 doctors and it's all fine, but they are definitely in the minority. And when you look at how many people see so many different doctors and take so many different kinds of medication prescribed by so many people, you can get it. You probably know someone in your own family who has multiple doctors. Maybe you yourself do. But the reality is that when you ignore that and force into the trust the two-doctor limitation, that is a problem waiting to burst into flame. So you want to know what the options are. Look at the list. At the end of this, next slide is a summary. Know what all the options are that other people have thought up. We've seen firsthand that they work. You have to know what could happen long after you draft the trust, and you have to educate the client that anyone, I don't care how smart you are, I don't care if you have a doctorate in economics, I don't care if you have been a financial advisor yourself, you have to know that the client can fall victim to cognitive impairment. It's a complicated illness. It is increasing in frequency, and there are preventive things that are sort of like preventing heart disease people just don't want to be bothered with. So you need to take control of the information that you advise your client, and don't rely on your software to do that for you. The client has to hear this, and you can put it in writing if you need to, but you use what works. Other lawyers have come up with these solutions. They're pretty smart. We've seen how much they have saved people from disaster. So just to reiterate, some of the things you can do instead of or besides having two doctors, you can have a vote of the heirs. You can have committee of younger friends or other group that your client appoints that decides incapacity, and you better make that clear. You can have one treating doctor. I've seen a lot of competent attorneys do that. If they know that the client has a doctor that is going to be there for a long time.
And extend the definition of doctor,
right?
That it's not just an MD. It could also be a licensed psychologist that can do that.
Exactly, because when most of them say two licensed physicians,
right.
That eliminates psychologists. They are not MDs, but they do something really helpful. So you can also, as an alternative, say that they need an assessment by a licensed testing psychologist with a written report. That's got the most hard data of anything you could find. Remember that the MD deciding this based on a 15-minute MOCA or MMPI is not a competent assessment. And what we have seen is that those are wrong as often as they are right. And Mikol explained to you why multiple testing is a much more reliable and valid source of information about incapacity. Then there is the under duress clause, which saved that widow, the wealthy woman who was getting ripped off by the boyfriend. And then the refusal to be evaluated upon written request, how much time would go by, what are the requirements. And again, with those where there has to be the successor trustee doing something, they typically have to swear out a declaration that they have attempted number 4 or number 5. And that sworn declaration needs to be prepared by an attorney because it has to have the right language. Most lay people, including doctors who are not lay people, they don't know what a declaration is. If you ask them what the wording is for a declaration, they're not going to know what to say. I draft those for people and have the client give it to the doctor, and that works fine. But swearing something under oath is specific language under the law. So if you're using the word declaration in your trust drafting language, be sure you know that most people don't know what that actually means from a legal point of view. Okay, so update the way you plan for clients with possible incapacity as they age. You've got an ethical responsibility as we see it, providing for the possibility of incapacity of somebody who's not going to be willing to see 2 doctors. You don't want to limit the determination of incapacity to the 2-doctor rule, which we consider to be quite dangerous. And we have some resources for you. I've published a book with the American Bar Association, working with aging clients, shopaba.org. It lists all of the domains of financial capacity in detail. And then this particular presentation today is based on a recent publication for an ABA newsletter publication that was published in December. And
we've got a bunch of other books that are available on our website on aging parents that are not just directed to other professionals. We have some for financial advisors, but also for families.
Right. Family Guide to Aging Parents, hiring a home care worker, what could possibly go wrong? These are things that are practical, again, based on stories from real cases that we've dealt with. We're in somewhat of a unique position sitting between legal expertise and healthcare expertise. And it's been my experience that lawyers don't know enough about the healthcare system, and healthcare people don't know enough about the law. That's why we're here. And Mikol has been a wonderful adjunct to what I do because he sees the emotional undercurrents of what's going on faster than I do. And when we are doing a family mediation, he gets there first, and it works quite well. So thank you for having us do this today.
Before we get into questions, I wanted to define testamentary capacity. What I'm hoping is that there are a whole bunch of very junior estate planning lawyers watching this. And it is something that they hammer if you are in an LLM program, but I think maybe a lot of practitioners haven't thought about this in a while. In order to have testamentary capacity, the bar is pretty low. You need to know who your heirs at law are. And I think that's why it's really important when you're drafting to include the list of the family members, because then you are showing in your work that you ask the client who are the natural objects of your bounty, which is, yeah. And then the other thing is, do you know what you have? And so getting that full list of the client's assets, and not just assets that would go into the trust, but ask them about their disability insurance, ask them about their mortgage rates. And now I'm thinking what we're going to start doing is we're going to ask clients, have you had a big change in your assets over the last 2 years? And if we hear, oh yeah, we had 500 in this account, but now we have 100. If it didn't go into a house, where did it go? Right? Because we're definitely not, as attorneys, trained to uncover whether or not somebody has capacity for financial transactions. We're just not. So I wanted to make that point because the bar is very low for testamentary capacity, even for creating a trust.
Missed the last part. The last part is understanding the consequences of giving those assets. So that's the third aspect, is understanding the effect of making that choice.
And I would say that the consequences of leaving your assets in certain ways to certain people is something that the estate planning bar does not spend enough time on.
Exactly.
It is the key to our entire practice here at Fonte Law. Estate planning with heart means we're looking at the way that the documents land on the successors and agents and on the beneficiaries and educating the clients. Because leaving your assets a third to your 3 kids probably isn't helpful.
I know one thing that's really helped the families that I've served is I'm a financial advisor. We do private banking, we do investing, we do some CFO services. I'm a huge advocate of going around the basics with all my families that I'm onboarding. And one of those key things is a financial plan, whether it be exhaustive or not. I'm going to document where all of your accounts are everywhere so that it's helpful for you, but it's also helpful for your family members. If there needs to be a cleanup, we know where all the bodies are buried or whatever. Call it a croak book, call it whatever you want, but we have our arms around all the accounts across the board, all the assets, real estate or otherwise. And we can reflect and celebrate what you got and also keep an eye on things when the values start to go down for some reason.
And do you get a permission slip from your clients to reach out to their successors and agents if you see things are going sideways?
You betcha. Yeah, we have a couple tiers at JP Morgan, anything from interested party, where we can discuss big picture, a trusted contact. Every account has to have a trusted contact. If we see trouble, I can call so-and-so and they will help me find you and they will help give me more context as to what's going on. And then, of course, we follow trust language based on the certificate of trust.
One of the issues that we see is that sometimes the trusted contact turns into the elder abuser.
Right.
Remember that family members are the most common abusers of all abusers. Right behind them are caregivers, and behind them in frequency, but bigger numbers, are professionals. So the trusted contact needs to be vetted pretty carefully, and there needs to be, I think, some other protection built in if the other family members, assuming there are some, determine that that person has seized too much power and is taking advantage of the decimated thinking process of that elder who has that big account with you.
Sorry, I just had a quick question. So I really liked your presentation. Thank you. I thought it was super informative. And it brought some really interesting ideas to mind. And I liked some of your strategies. But my question is, for those clients that are very particular and very controlling, and when we draft for them, and they have like a very specific thing in mind, and they're already like, I don't even want 2 doctors. I want a panel of doctors. I want this. Right. And so what's your advice for talking to some of those clients to say, like, look, I think it's great that you want to manage your accounts and that you really want to make sure that you're in control and that you can't be deemed incapacitated easily. But sometimes you said like dementia happens quickly and your loved ones need to act quickly when that happens. Like what's your advice for talking to those clients and saying like, look, this might alarm you, but this language is really meant to help you?
It's meant for protection. And here's the reality. If they want a panel of doctors, again, we're back to the same problem. Which one? The podiatrist, the orthopedic surgeon, the cardiologist? Do you know how much Medicare gives a doctor to see a patient? 15 minutes. 15 minutes for an office visit. Do they think that 15 minutes is enough to do not only the treatment that they're going there for, maybe it's a medication reassessment, maybe it's an adjustment with the high blood pressure pills, whatever. They got to assess that, and they're going to do a cognitive assessment in 15 minutes. Educate the client. They need a reality check. You may not be as familiar with the medical system, but we're hoping that this presentation has helped you get a clue. It's broken. That's all I can tell you.
But at the level of which there's an urgency to even question the person's capacity, assuming you're going to get a panel of experts, doctors, that are going to come together and act, it's insane. It's some kind of TV romantic idea that that's going to protect and save them. I mean, we know primarily for people to get appointments with their primary care doctors these days, it takes months to just schedule an appointment.
Yeah.
And they don't have the capacity to have an urgent appointment and be able to do a capacity evaluation. That's why I step in often and will even go to the home directly and do the evaluation, because these things, when they happen at a level of great urgency because, you know, money has already been abused, or it's clear that the person doesn't have the capacity to act in their role that they are. And there's a real level of immediacy that needs to happen. So I think educating your clients about these are the kind of problems that can happen that will thwart your effort to protect your assets.
Mikol's record turnaround time, not 6 months, not 2 months. Didn't you do one where it was an emergency? You ran out, saw the client at their house, came back, wrote the report, 48 hours. We had a 48-hour record on how speedy this could be done, but that is unusual.
I want to point out that for the Wealth Council drafters here, that in the basic Wealth Council language, because there's, you know, you can pick the doctor, the panel, that, but then there's also detention, disappearance, and absence. And within that definition is the held under duress language. I immediately had to go look at it. And so that is there. Bridget.
Yes, thank you for the presentation. It's great. My question is, if you have a panel, and I've used language like this actually, because Carolyn, I've heard you speak before, and so I always remember your examples. Like, will financial institutions easily accept those determinations by family members and panels? Like, if you have a group of family members declare a person incapacitated, they sign, like, have you ever seen problems with that?
Absolutely. We see problems a lot. We see problems with the power of attorney when somebody is already out of commission and the POA agent is going to the bank saying, look, you know, my mom is getting ripped off and just gave money to the Prince of Arabia, and we need to stop this. So I need her to stop having control over that account that she's using to send checks to somebody she met on the internet. And the banks say, oh, well, she has to come in. Well, she's in a wheelchair and she's mostly bedridden and she can't come in. Well, she has to come in because she's the customer. We don't care about your power of attorney. This is a serious problem with financial institutions. Okay.
So let's take a moment for a practice tip. We do use the long form Wealth Council 30-page monster power of attorney, but we also really push our clients to use the California uniform, which is effective immediately, and the powers are very broad. But it's not the end of the story, because I would really like our clients to go into the bank and stress test that document. And because the teller is going to be afraid of it, you know, they're afraid of elder abuse, they're afraid of fraud, they're afraid of the nefarious nephew. So you could always go into the financial institution and sign their own form of power of attorney. What you don't want to do is just put other people on your accounts, because that's a whole other set of problems. But signing the power of attorney directly with that financial institution is very difficult for them to reject their own form.
That's often what they want.
Yeah, that's a problem, though, because the form they have is limited. It's not a durable power of attorney. I tested this out myself because we had changed financial institutions and management, and I had had so many stories that I raised this issue, and their compliance department got very upset because I was asking all these questions. And I said, will you accept our power of attorney document, not yours? We'll serve yours, do whatever you want. I looked at theirs, and it was not a durable power of attorney. So if you're out of it, it's sort of illegal to be respecting it.
Interesting.
In any case, you look at it. You look at that financial institution's power of attorney, pretty much it's until you don't have capacity anymore, and then it's no good. So be very careful about that. What we did in our own case, because I'd had so many stumbling blocks with other clients that I'd seen, is I got them to agree that our appointee agent would be able to act on our behalf regardless with the document we had her sign and signed ourselves.
Are there any other questions? Anybody else wondering something?
It's a huge boon to have a financial advisor working behind the scenes to hopefully smooth things out. I've been able to do that for a couple of clients because the machine is what the machine is, and bankers just love red tape and right angles. So to have someone behind the scenes to be the advocate is huge, well worth the fee that would go with it.
Yes, and we focused on the financial services industry because we have discovered that there's not a lot of education about cognitive impairment there. I have 2 books, Best Practices for Financial Advisors and Succeed with Senior Clients. Those are designed to help you deal with the unfortunate circumstances you run into where the client has not gotten a good estate plan, and you've got to try to make sure they're protected when somebody in the family that maybe they've appointed as an agent is ripping them off. And that is a high-risk situation. A lot of people don't have a financial advisor. A lot of people don't have someone looking out for them. And the idea of a trusted contact, according to the SEC and FINRA, it's not mandatory. Am I right? Your institution has chosen to do that, but most financial...
Right. Yeah, it's an internal thing, but it's not law.
Well, that's the problem. Not everybody's at JP Morgan. So the ones who have
Come on over. The water's warm.
to come to you, yes. No, it's just it's an issue that banks make up their own rules. They want 2 doctors too sometimes. They got no business telling you what your trust isn't supposed to do, but they do that. And they refuse to accept these power of attorney documents drafted by you, the estate planner. That's an issue.
Well, in our last 2 minutes, I want to leave with some practice tips. It is really critical as an estate planning attorney that you're seeing your client every 3 to 5 years, and take copious notes and ask them a lot of questions about themselves. But also when I check in with clients, I'm asking them about their parents. Is mom becoming forgetful? What else is happening? I'm going to use the information here to create a template email that I can then send to my client so that they can actually do a really good review of mom and dad's trust and power of attorney to make sure that the incapacity triggers, if necessary, that they're going to work. So I think, and then also, Carolyn, I think it came from you. The American Bar Association has an advanced healthcare directive workbook, but there's another directive workbook specifically for people who have received a diagnosis. And it is a wonderful talking tool for my clients to use with their parents, because it's all about control. What am I supposed to do for you? How do I take care of you? I'm worried. And so clients have been very, very grateful to receive that. And I know that when I have a client who tells me that they've received a dementia diagnosis, I pass them on to another lawyer because this is not an area of expertise for me. I'm not an elder lawyer, and I don't know how to spot fraud and abuse and duress. And I think it's a very different practice. I don't know that I would be able to spot it in a client. And you're telling me that after 65, the risk doubles every 5 years. So I really have to think as a business owner about the age of my clients. This has just been a lot to think about and unpack.
Well, thank you. I think you sound like you're doing an excellent job being proactive, Patricia, and we really appreciate the opportunity to share this with people. We just hope we'll save at least one person from financial abuse by doing this. So we thank all of you for having us today.